Hello, my name is Dominic Woodhouse from Partners in Costs. Because we can't get out to see you all at the moment, we thought we'd put together a short series of videos dealing with the key rules and requirements in relation to cost budgeting. So first, what is cost budgeting? Well, per CPR 3.15, in addition to exercising its other powers, the court may manage the cost to be incurred by any party in any proceedings. The costs to be incurred are referred to as the budgeted costs. Pausing next, it's important, and we'll look at various rules in a little more detail than they perhaps appear to first justify. CPR 3.15 is giving us a very clear pointer in relation to the powers of the court when budgeting. It may manage the cost to be incurred by any party in any proceedings, so it's managing future costs, a prospective power. There are, or I suppose battle lines have been drawn to some extent, as we'll see, in relation to the court's control over costs and how incurred costs feature within the budgeting regime. But it is important to remember, first of all, per CPR 3.15, it's a prospective power. We then go on to CPR 3.15.2. The court may at any time make a cost management order. Where cost budgets have been filed and exchanged, the court will make a cost management order unless it's satisfied that the litigation be conducted justly and at proportionate cost in accordance with the overriding objective without such an order being made. So again, pausing there to unpack the rule a little. The court may at any time make a cost management order. As we'll go on to see, there are specific periods or times at which a budget has to be filed and served in relation to proceedings to which the budgeting regime relates. It is, however, open to the court to direct service of a budget at any time during the course of those proceedings. Taking as an example, if, for instance, you proceeded all the way through proceedings without being subject to budgeting or without having a budget imposed upon you, and the case is a few months away from trial, at that point it would still be open to the court to then impose a budget, even if no budget had previously been set. Pausing again to consider the second sentence. Where cost budgets have been filed and exchanged, the court will make a cost management order unless it's satisfied that the litigation can be conducted justly and at proportionate cost. That is a change from the original incarnation of the rule, which was much more flexible for the courts. The courts could, or I think the wording was, that they may make a cost management order. That wording was changed so as to make it more robust, to bolster it, to make it more of an obligation on the courts to actually conduct cost management. So in claims and proceedings to which the cost management regime relates, then there will be a much greater likelihood that cost budgeting will be carried out by the courts. Gone are the dark days when the suspicion was that most judges and courts were perhaps trying to avoid it somewhat. That takes us on to the second part of CPR 3.15.2, which explains what a cost management order actually does. By a cost management order, the court will, firstly, record the extent to which the budgeted costs are agreed between the parties. Secondly, in respect of the budgeted costs which are not agreed, it will record the court's approval after making appropriate revisions. And thirdly and finally, it will record the extent, if any, to which incurred costs are agreed. So again, unpacking that and diving into it in a little bit more detail, taking the last one first, record the extent, if any, to which incurred costs are agreed. As we've briefly mentioned already, and we'll go on to look at in a little more detail, there is a great distinction to be drawn between incurred costs and estimated costs. The court is controlling the future and estimated costs. It is not controlling or assessing the incurred costs. After this series after we've completed this initial series of videos looking at the rules and the key requirements, we'll then take a little more in-depth review of cases and case law bearing upon specific issues that come into play in relation to budgeting. One of which is this tension between incurred costs and estimated costs. As we'll see, the court is able to comment in relation to incurred costs and it will take them into account when setting the budget. The difficulty is in knowing how that is. But just to pause in relation to 3.15.2c, the record the extent, if any, to which incurred costs are agreed. As we'll see per a case of Harrison, which we'll look at in more detail later, the incurred costs aren't part of the cost management order. The court doesn't control them. It's relatively anomalous that there is a provision in it for the court to record the extent, if any, to which incurred costs are agreed. Ordinarily, your opponent won't be agreeing your incurred costs, and you, as like as not, will want to agree your opponent's incurred costs. If it is the case that for some specific reason, for instance, perhaps that the incurred costs are extremely low, it may be that you want to specifically agree your opponent's costs. If so, then, of course, within the cost management order, you want the court to make that record, though it wouldn't be a certainty that your opponent would later be able to seek more than you appear to have agreed to be paid in respect of incurred costs, given that they aren't part of the cost management order. The first point states that the cost management order will record the extent to which the budgeted costs are agreed between the parties, and secondly, in respect of the budgeted costs which are not agreed, record the court's approval after making appropriate revisions. So this again is an extremely important provision within the budgeting rules. It restricts the court's powers when it comes to dealing with budgeting and the way in which it should make cost management orders and deal with costs and case management conferences, because it shows that the only powers the court has are in relation to the aspects of the budget or the phases of the budget which aren't agreed between the parties. You may well attend at a CMC where the court, despite the parties having agreed various aspects of the budgets between them, so phases of the budget between them, it may be that you encounter judges that take the view that if you haven't agreed the entirety of the budget, then they have to assess it all. If that isn't what you want to happen, then you will be wanting to take them back to this provision to show that actually their powers are rather more restricted than they might presume to be the case. That takes us on to CPR 3.15.3. If a cost management order has been made, the court will thereafter control the parties' budgets in respect of recoverable costs. Again, not wanting to labour the point, but this is, again, an important provision. And it comes into all issues about what fall to be considered as incurred costs in a budget, what falls to be considered as estimated costs, and the point at which the court takes control of those budgets and which costs exactly it can budget. So if a cost management order has been made, as we'll see in analysis of cases later in this series, there is argument that from that point on, the court can then control costs. So if 2 months before trial you seek to vary your budget to make provision for some aspect which hadn't been foreseen originally, but which has already been dealt with, it may well be the case that the court does in fact have power to budget those costs, notwithstanding that they have already been incurred. It is a difficult and slightly problematic point, both in principle and practice. It's not something we're going to delve into in too much detail right at this moment, but we will come back to it later in the series. That takes us on to CPR 3.15.4, and whether or not the court makes a cost management order, it may record on the face of any case management order any comments it has about the incurred costs, which are to be taken into account in any subsequent assessment proceedings. So briefly flagged up that tension between incurred costs and estimated costs. We'll be coming back to that, but again, here is a power which enables the court to make comments about the costs, the incurred costs, even if there has not been a cost management order made, and which therefore will be taken into account in the detailed assessment proceedings. The weight that is attached to those comments will be determined on a case-by-case basis, and certainly, especially in the context of a CMC, which is probably quite short, and in which you likely won't have the opportunity to explain to a judge all the different reasons why your incurred costs are what they are. And you may feel like you're doing the client a disservice and aren't able to put forward all of the justification that you want to while that case is ongoing. Then you can breathe to some extent slightly more easily, because there will be an opportunity to influence how those comments are later interpreted in the assessment proceedings. It does flag up the importance of making very very full and accurate notes of any comments made by judges, so you can definitely later put them in the proper context. That takes us on to CPR 3.18, and one of the first major reasons as to why I suppose there was a certain amount of apprehension and fear in relation to budgeting when it was first introduced, and certainly why it remains such an important issue. Under CPR 3.18, in any case where a cost management order has been made and costs have been assessed on a standard basis, and the court will firstly have regard to the receiving party's last approved or agreed budget for each phase of the proceedings, and secondly, it won't depart from such approved or agreed budget unless it's satisfied that there's good reason to do so. Pausing briefly there, we'll come on to look at in later videos various cases surrounding the interpretation of what's meant by the court not departing from the approved budget. But for our purposes at the moment, it's important to recognise that it does effectively exactly what it says on the tin. Unless you can satisfy the courts that there is good reason to depart from the budget, the cost will be very much limited to and restricted by the budget, subject to compliance with the indemnity principle. But as I say, we'll come back to that in later sessions. Thirdly, within the provisions of 3.18, the court will take into account any comments which have been made pursuant to Rule 3.15.4 or paragraph 7.4 of the practice direction. So again, that gives that mechanism for the court to take into account comments made by the court when it was dealing with budgeting and setting directions and so forth. So fundamentally, the budget will greatly influence, if not almost entirely determine your eventual cost claim and recovery in a great many cases. So it's absolutely essential that it's done right and there's complete compliance with the rules. That takes us on to CPR 3.12.1. Because what cases does budgeting actually apply to? Or in what circumstances does it apply? Well, unless the court orders otherwise, budgeting applies to all Part 7 multi-track claims, subject to some exceptions. CPR 3.12.1 sets out those exceptions as follows. So budgeting doesn't apply to claims which were commenced on or after the 22nd of April 2014, and the amount of money claimed on the claim form is £10 million or more. Secondly, it also doesn't apply to claims which are commenced on or after the 22nd of April 2014, which is for a money claim but which is not quantified or is not fully quantified, or is for a non-monetary claim, and in any such case the claim form contains a statement that the claim is valued at £10 million or more. Thirdly, it doesn't apply to claims where proceedings are commenced on or after the 6th of April 2016 and a claim is made by or on behalf of a person under the age of 18. The extension to that provision is that in such claims to which it applies, on the child then reaching their majority, the exception will continue to apply unless the court orders otherwise. We will be seeing a lot of those provisions where the court retains the power to order otherwise than that for which the rules themselves provide. Fourthly, it doesn't apply where proceedings are subject to fixed costs or scale costs, which is probably fairly self-evident the reason why, because the court won't need to exercise control over costs if they are actually fixed by the rules. Lastly, it doesn't apply to claims where the court otherwise orders. So in all circumstances where budgeting does apply, then it applies and you have to comply with the rules. It may be the case that you don't feel that your particular claim is appropriate for budgeting, or it's not appropriate for budgeting to be applied at the time that the rules provide for, which we go on to look at. In that instance, if you want to have budgeting disapplied, then it will be necessary to make an application to the court, hopefully by consent if you can get the cooperation of your opponent, asking that it to disapply budgeting. It retains that power. That takes us on to Practice Direction 3E and 2B. In cases where the claimant has a severely limited or impaired life expectancy, then the court will ordinarily disapply cost management. Pausing there, it's important to observe that that is not an automatic provision. Ordinarily, it will disapply budgeting in those cases, but until the court actually does specifically disapply budgeting, then it will be necessary to comply with the relevant rules if budgeting would otherwise apply. So if you are dealing with such an unfortunate case, then do try and look at that issue as early as possible, get the agreement of your opponent and make representations to the court asking for budgeting to be dispensed with or disapplied before it becomes necessary for you to file and serve your budget. What do we look at then? Well, we need to know when you have to file and serve your budget. That's pretty important, as we'll see, because there are sanctions around failure to comply with the time limits. So it's incredibly important that we know when budgets have to be filed and served and make sure that we in fact do. So under CPR 3.13.1, unless the court otherwise orders, all parties except litigants in person must file and exchange budgets where the stated value of the claim on the claim form is less than £50,000, they're with their directions questionnaires, or in any other case, not later than 21 days before the first case management conference. So if it's less than £50,000, if it's £49,999, then it needs to go with your directions questionnaire. If the value on the claim form is £50,000 or more, then it needs to go no later than 21 days before the first case management conference. As always, references to days here are references to clear days. You need to make sure that you compute those correctly to make sure that you don't find yourself inadvertently in breach of the rules. Why is this so important? What happens if you don't file and serve your budget on time? Well, this is where that real fear factor from introduction of the rules initially crept in and to some extent still exists, because of course it is a very draconian sanction. Under CPR 3.14, unless the court otherwise orders, any party which fails to file a budget despite being required to do so will be treated as having filed a budget comprising only the applicable court fees. So you can readily see that in the context of a particular case, that would be an extremely bad event. In the context of a basket of cases across a firm, that could be absolutely catastrophic. So it's essential that the budgeting regime and the rules are complied with in every respect. That completes our first unpacking of the key rules and requirements video, and I look forward to next time. Stay safe.